Peace and love all. Prince L coming to you with the Model Trust Core. Just a little research and information. This video is for educational, informational, and mildly entertaining purposes only. I am not a lawyer. I'm just someone who does a lot of research, who takes a very big interest in protecting my financial interests, now and in the future. Because I want to be able to have something to pass on to my children, and I want something for my children to be able to pass on to their children. So today I'm going to be touching on some common violations uncovered by the Consumer Financial Protection Bureau regarding real estate, Settlement Protections Act, and the Truth in Lending Act, all relating to or pertaining to mortgage foreclosure. All right. So here it is that I found a number of articles, but I felt like this was one of the most interesting. This guy or this company that you see up here, Jirachi, I don't receive any type of compensation from them. I just found that their information was relevant and useful. So once again, I'm not a lawyer, but I like to find out what lawyers think. And apparently this article was written by a lawyer, Esquire, Jirachi Law Firm. You want to find out, you want more information, contact them. Their number is there. All right. Consumer Financial Protection Bureau released its winter 2015 edition of supervisory highlights for the mortgage industry. Now, I'm not going to insult your intelligence. I'm going to scroll through this at a fairly quick pace and get into some of the common violations. But the act, since the Dodd-Frank Act passed, the CFPB has stepped up efforts to ensure fairness and transparency with the lending and consumer finance industry. All right. So they're talking to the Consumer Financial Protection Bureaus, which is regulated by the Federal Trade Commission, all right, the FTC. All right. The CFPB is an enforcement agency. Right, they enforce the laws, but they also receive complaints from consumers regarding, bad business. All right, so you may also want to consider contacting the Better Business Bureau, BBB. All right, let's go through these rules or some of these violations. Failing to establish and maintain written policies and procedures under the loan origination rule. Now, you must be able to look at these following violations or these following common violations and determine what pertains to you. Not all of this information pertains to your unique situation and circumstance. You must be discerning in what you're taking in and how to apply it. All right. So let's get into it. The loan origination rule is part of the Truth in Lending Act, TILA, T-I-L-A, and requires that a lender discloses loan originator compensation to the borrower in order to protect them from being directed into loans with unfavorable terms. The CFPB determined that lenders failed to establish written policies and procedures instructing employees on how to comply with current regulations. Lenders were directed to implement and maintain written procedures that guide their employees on the importance of maintaining compliance with TILA. Now, I also took the liberty of pulling up some information on the Truth in Lending Act. All right, violations and foreclosures, all law. You see the website up there. It's also a NOLO article. I do enjoy NOLO's products. I will say that much. I'm not being endorsed by them. At least, who knows what the future may hold, right? Truth in Lending Act is a federal law that was created to ensure that consumers receive accurate information when they enter into credit transactions. TILA covers consumer credit loans, including mortgages, credit cards, and home equity loans, and was designed so that the disclosures given to consumers would be consistent, and standardized. This law requires a creditor to disclose certain information in writing regarding the terms of a credit transaction. There are two types of TILA violations that can provide relief to borrowers when a creditor does not adhere to the law: violations for damages and violations that allow rescission. Rescission is the remedy that may help if you're facing foreclosure, as you'll see below. So let's get straight into violations allowing rescission. But I'm going to touch on some points real quick in the TILA violations for damages. All right. Any actual damages sustained by a person as a result of the failure, and statutory damages limited to twice the finance charge, but not less than $400 and not more than $4,000. So this is like basically a small claims form of act, all right, or protection, all right, Truth in Lending Act, all right. So for the consumers that the disclosures that may have not been provided to you as a borrower because the creditor did not do so, it would be those creditors would be liable to pay damages in an amount equal to the sum of any actual damages sustained by a person as a result of the failure. So if you're talking with the CFPB and basically they're going through making their decision or judgment call, which they may cross-reference or see what the Better Business Bureau may say as far as like how these types of practices affect the ability of the public to trust these corporations from fraudulent activities. All right, this is just things to take into consideration. Material violations that are grounds for damage include, but are not limited to, improper disclosure amount to finance charge. Under TILA, a creditor is considered strictly liable for any violations. A creditor is considered strictly liable for any violation. This means money damages are imposed for the violations regardless of the creditor's intent. That's major protection. All right, but you have to look into these types of things to understand them. TILA violations allowing rescission. All right, I'll come back to TILA in a little bit, but TILA's got some good information, as you can see. All right, failing to comply with disclosure requirements concerning the list of home ownership counseling organizations. The CFPB found that lending entities failed to comply with the Real Estate Settlement Procedures Act, RESPA, but not adequately providing the correct website addresses of housing counseling agencies to consumers. The noncompliance was apparently due to an oversight by lenders, who then took action to rectify the information on their disclosure form. All right. Now, that's also powerful information right there, because most borrowers or most individuals who take on a mortgage fail to comprehend that part of what they're signing. They have protections under the Real Estate Settlement Procedures Act, meaning like if a company or a bank were to make begin the foreclosure process, basically they would have to comply with certain rules and regulations that are enforced by the CFPB, right? And if they have to do that within 30 days. Now I have some RESPA information right over here. Let me just pull that up for you real quick so you can also see again on alllaw.com. All right, RESPA violations and foreclosure. All right. Under RESPA, your mortgage servicer is required to provide you certain information related to your loan to correct any errors. If not, you can sue and recover money damages. But they have to correct those errors. If they can't correct those errors, you can sue them, and recover whatever money damages that may be, owed to you. All right. Real Estate Settlement Procedures Act, Real Estate Settlement Procedures Act was enacted to protect consumers and primarily requires mortgage lenders, servicers, and brokers to provide borrowers with certain disclosures regarding the nature and costs related to the purchase of real estate. While RESPA contains many protections for consumers, the section that may be most powerful for borrowers facing foreclosure is Section 6, which pertains to qualified written requests. Okay? What is a qualified written request? This is powerful information because they, often I've seen letters as an individual who assists, who specializes in credit repair. I've seen where there's been plenty of mention with the RESPA Act. Now, I always ask my clients, do how old is this debt? Like, because based on the 24 month period, that's when a company is actually seeking, or a collector or a creditor may be seeking to collect or enforce a foreclosure on a debt that is over 180 days. All right. Now, if you want to double check that for yourself, I strongly encourage you to double check that for yourself. But often, many of these mortgage companies would pretend that they don't, the documents that they're receiving do not qualify as a written request. But let's understand what a qualified written request is. All right, or a QWR is a written letter sent to the mortgage servicer that, one, requests information pertaining to the mortgage loan, or two, requests that the servicer correct an error such as unwarranted late charges or misapplied payments. The correspondence can both dispute a servicer action and seek information. Either request by itself qualifies as a QWR. All right. Additionally, a request for information about the status of a loan modification qualifies as a QWR. And you can review the case law, Woods versus Greenpoint Mortgage Funding Incorporated, 2010, WL 1729711. ED Cal April 28, 2010. All right. In that correspondence or affidavit, it must include or enable the servicer to be able to identify the name and account of the borrower, as well as a statement of the reasons why the borrower believes that the account is in error, or a detailed description of the information the borrower is seeking. That's codified in 12 U.S.C. 2605, subsections E1 Bravo. B. Any written document such as a typed letter or handwritten note will suffice as a QWR. Look at that. Or handwritten. So you don't have to be tech savvy. You could just write the document out by hand and make sure that your penmanship is fairly legible, meaning like it's big enough to be read, okay? And it will suffice as a QWR, although the request may not be written on the payment coupon or other payment media supplied by the servicer. All right. It may not be written on the payment coupon or other payment media supplied by the servicer, meaning putting certain letters and numbers across a document and saying, oh, this is just going to be it. That won't do. That does not qualify as a qualified written request. So for all the individuals out there who think that you could just put some letters and some numbers on a piece of paper that the servicer themselves provided you, it will not be considered as a valid request, okay? A valid written request, or a qualified written request, all right? To be considered a qualified written request, QWR, the letter must be sent to the loan servicer, not to any other party related to the loan, and should identify itself as a qualified written request under Section 6 of RESPA. A sample QWR is available on the website of the Department of Housing and Urban Development, HUD. We're going to talk about HUD in just a second, but let's go back over here so we can get into some more of these common violations. Failing to comply fully with RESPA's requirements for the GFE. Okay, RESPA requires a lender to deliver a good faith estimate to a consumer within 3 business days of receipt of a finished loan application. All right. Examiners found that the lenders had failed to comply with this rule by not providing the good faith estimate, GFE, within the specified time frame, and by failing to include all applicable fees incurred by the borrower. All right. So, good faith estimate. All right. That's supposed to be included in your mortgage document. Your mortgage and your promissory notes is supposed to be on those contracts. And those are 2 different documents, okay? So, and the promissory note is essentially the deed. If you comprehend that. All right. Let's see. Failure to comply with RESPA's requirements for completion of the HUD of the HUD. All right. RESPA requires the HUD Housing and Urban Development Settlement Statement to accurately reflect the fees and charges being paid by the borrower at the close of the loan. Examiners found violations and ordered those customers affected by incorrect housing and urban development settlement charges to be refunded the appropriate amounts. So people were being awarded back their damages or refunded their appropriate amounts when certain mortgagors failed to fully comply with the requirements for completion of the housing and urban development settlement statement. All right, which once again accurately reflect the fees and charges being paid by the borrower at the close of the loan. All right. So once again, that should be somewhere on the promissory note, which is secured by the mortgage note. Okay. Let me see. I recall having some housing and urban development information, but let me double check where that might be. Nope. We got Tila. Let's get the eight. Let's get HUD on the line, right? HUD. Housing and urban development. Look at that. Let's look at some of these Google responses that come up. All right. HUD homes, foreclosed homes don't last long. Find your home before everyone else. Search by zip code. Let's keep going. All right. HUD.gov. All right. Let's look at HUD violations. Because I think that's where we're looking for remedy. We're not looking for, we're not trying to, get too hobnobby with these individuals. We just want to. Is I think we're running the system a little too hot right now. Running the system too hot. Too much cheap. That it didn't change the format on me. Some people might say the Matrix has you. Well, when you're researching, yeah, of course, you're researching public information. Nothing to hide here, right? Nothing, it's all right in front of us. Nothing to see here. That's what some people want you to say. Nothing to see here. Hey, keep it moving. Move along. Nothing to see here. HUD violations. Click. And we search. Report fraud. Office of Inspector General, Department of Housing and Urban Development. Housing and Urban Development. Let's take a look at what Housing and Urban Development says. And then we're going to go check out another site. Help HUD's secretary to ensure the integrity of departmental operations by reporting suspected fraud, waste, abuse, or gross mismanagement in HUD programs or operations. Look at that. Help them report suspected fraud, waste, and abuse. Fraud, waste, and abuse, my friends, whoo. You think the corporation gets mad when people start making money without them? They get even more mad when there's a misappropriation of funds. You can't. In other words, they gotta hold some type of honor amongst their agency. You know what I'm saying? So, AKA, honor amongst thieves. So, people need to be honorable, at least with their own organization. Let's check out this other site. Fair housing. It's your right. HUD is ready to help with any problem of housing discrimination. Do you think this is about discrimination? Let's take a look at this. The Fair Housing Act protects people from discrimination when they are renting, buying, or securing financing for any housing. The prohibition specifically covered discrimination because of race, color, national origin, religion, sex, disability, and the presence of children. Learn more. Get basic facts about the Fair Housing Act. If you think your rights have been violated, what happens when you file a complaint? Let's go through this, all right? What housing is covered? The Fair Housing Act covers most housing. In some circumstances, the act exempts owner-occupied buildings with no more than 4 units, single-family housing, sold or rented without the use of a broker, and using operated by organizations and private clubs that limit occupancy to members. Ooh, what is prohibited? In the sale and rental of housing, no one may take any of the following actions based on race, color, national origin, religion, sex, familial status, or handicap. Refuse to rent or sell housing. Refuse to negotiate for housing. Make housing unavailable. Ooh. Deny a dwelling. Set different terms, conditions, or privileges for sale or rental of a dwelling. Provide different housing services for or facilities. Falsely deny that housing is available for inspection, sale, or rental. Look at that. So, like, you don't have to be a homeowner. You could just be someone who is renting a house. It may not even pertain to a mortgage. It might just pertain to a rental disagreement. Is your housing or your rental property covered underneath the housing and urban development? All right. Is it protected, or are they under the jurisdiction of the Fair Housing Act within your state? Because understand that the Fair Housing Act, this is a federal regulation, not a state regulation. All right. So if you feel that you are being violated, your federal rights, your national rights are being violated, you need to go ahead and contact the person. You know what I'm saying? What is prohibited? In the sale and rental of housing, no one may take any of the following actions based on race, color, national origin, sex, familial status, or handicap. And we're about to close this out, ladies and gentlemen, because I don't want to overload you, but I want you to be able to see there is information out here for you to go ahead and take the necessary steps to help protect your assets, because I'm always just curious when I also see like wills and trusts come across, and they're like, people are putting houses into trust, and people are putting their vehicles into trust and estates, and I always I'm very curious about that. So let my curiosity towards how to protect those assets, because I essentially understand that, placing property into trust or estates is a way of protecting assets of the participants and beneficiaries of that trust and estate. So, things to always just be aware of and to always take into consideration. All right. In mortgage lending, no one may take any of the following: refuse to make mortgage loan, refuse to provide information regarding loans, impose different terms or conditions on a loan. In addition, it is illegal for anyone to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise that right. Ooh. Once again, this is not legal advice, but I'm assisting in providing research assistance to those who seek to exercise their rights. All right? Advertise or make any statement that indicates a limitation or preference based on race, color, national origin, religion, sex, familial status, or handicap. This prohibition against discriminatory advertising applies to a single family and owner occupied housing that is otherwise exempt from the Fair Housing Act. If you think your rights have been violated, let's see what they say. HUD is ready to help with any problem of the housing discrimination. If you think your rights have been violated, the housing discrimination complaint form is available to you to download, complete, and return, or complete online and submit. Or you may write HUD a letter or telephone the HUD office nearest you. You have 1 year after an alleged violation to file a complaint with HUD, but you should file it as soon as possible. What to tell HUD? Your name and address, okay, or your appellation or your title, and your, place of residency or business, the name and address of the person your complaint is against, the address of the other identification to the housing involved, a short description to the alleged violation, the event that caused you to believe your rights were violated, the dates to the alleged violation, where to write or call. Send the housing discrimination complaint form or a letter to the HUD office nearest you, or you may call that office directly. If you are disabled, HUD also provides a toll-free number. What happens when you file a complaint? Let's find out. HUD will notify you when it receives your complaint. Normally, HUD also will notify the alleged violator of your complaint and permit that person to submit an answer. Hey, we don't want to seem biased, so we're going to give you an opportunity to respond to these allegations that have been made against you. This face to face with the complainant. All right. Investigate your complaint and determine whether there is reasonable cause to believe the Fair Housing Act has been violated. Notify you if you cannot complete an investigation within 100 days of receiving your complaint. Conciliation. HUD will try to reach an agreement with the person your complaint is against, the respondent. A conciliation agreement must protect both you and the public interest. If an agreement is signed, HUD will take no further action on your complaint. However, if HUD has reasonable cause to believe that a conciliation agreement is breached, HUD will recommend that the Attorney General file suit against the party injuring another party or damaging another party. Basically, these are financial crimes. These are consumer-related crimes, all right? Complaint referrals. If HUD has determined that your state or local agency has the same fair housing powers as HUD, HUD will refer your complaint to that agency for investigation and notify you of the referral. That agency must begin work on your complaint within 30 days or HUD may take it back. What if you need help quickly? If you need immediate help to stop a serious problem that is being caused by a Fair Housing Act violation, HUD may be able to assist you as you file a complaint. HUD may authorize the Attorney General to go to court to seek temporary and preliminary relief pending the outcome of your complaint. If irreparable harm is likely to occur without HUD's intervention, there is substantial evidence that a violation of the Fair Housing Act occurred. Example, a builder agrees to sell a house, but after learning the buyer is black, fails to keep the agreement. The buyer files a complaint with HUD. HUD may authorize the Attorney General to go to court to prevent a sale to any other buyer until HUD investigates the complaint. That's basically a lien, ladies and gentlemen. What happens after a complaint investigation? If after investigation your complaint HUD finds reasonable cause to believe that your discrimination occurred, it will inform you. Your cause will be heard in an administrative hearing within 120 days unless you or the respondent want the case to be heard in federal district court. Either way, there is no cost to you. This is free, ladies and gentlemen, as this information that you are receiving is. All right, let's go back to this compliance violations, okay? And then I'm going to let you go. I'm just going to let you go because I think if you're feeling like I feel, you're feeling a little inspired, all right, to draft up that complaint and start doing your due diligence and making sure that your rights as a consumer, as an individual doing business within the states and within the nation, those rights are not infringed upon, okay? Deceptive practices from broad waiver and home equity loan installment agreements. Examiners found that lenders were misleading consumers by demanding they sign a waiver of individual rights, whereas the CFPB deemed such a waiver as unenforceable. Why? Why would they say that such a waiver is unenforceable? Because that violates full disclosure. Okay? Simple as that. The CFPB concluded that a consumer may be misled by the waiver, not having full disclosure, believing they are waiving their statutory rights to the notification and delivery of demands regarding the delivery, acceptance, performance, default, or enforcement of their notes, and therefore would be less likely to assert said rights. Lenders were directed to cease requirement consumers to sign such broad waivers and replace consumer documents with a more limited exemption. 6. Failure to provide adverse action notices promptly. Under the Equal Credit Opportunity Act, lenders are required to notify the applicant of adverse measures taken within 30 days after receiving a completed application. Examiners found that lenders had failed to provide notices promptly in violation of the requirements of the ECOA, the Equal Credit Opportunity Act. So, check the dates on the notices that you receive regarding any foreclosure or even or any other adverse actions that are being taken against you and your property, or any individual and their property. Number 7, failure to provide adequate notices to loss mitigation application. RESPA requires that borrowers who are seeking payment assistance through a loss mitigation application be notified in writing by the servicer within 5 days of receiving the application. The notice must indicate if the application is complete or incomplete, and if incomplete, list the documentation required to complete the application process. Examiners found that at least one servicer issued out loss mitigation acknowledgments that required excessive documentation in violation of RESPA. Let me reread that last part. All right. The notice must indicate if the application is complete or incomplete, and if incomplete, list the documentation required to complete the application process. Examiners found that at least one servicer issued out loss mitigation acknowledgments that required excessive documentation in violation of RESPA. All right. Stuff to think about. Number 8, sending incorrect intent to foreclose notices. The CFPB found that servicers sent the incorrect intent to foreclose notices to borrowers who were approved for a loan modification before their first trial payment was received. Sometimes people are not even being offered a loan modification regarding their foreclosure. Continuing, they also concluded that the servicer had neglected to verify if the borrower had a pending trial modification plan before sending out foreclosure notices. So, where is that pending trial modification plan? Where is that loan modification plan at before it goes into, litigation, before it goes to the court, before lawsuits are filed, That sounds like, a complete violation of a person's right to be secure in their person and in their property. But hey, what do I know? Failure to send account statements. Under TILA, servicing agents are required to send out statements each billing cycle that displays the account's transaction history and documents activity that would lead to a credit or debit and the amounts due. Examiners found that some services were neglecting to send out the documentation that conformed to the Truth in Lending Act. I'll reread that for you. Examiners found that some services were neglecting to send out the documentation that conformed to the Truth in Lending Act. Failure to comply with the Homeowners Protection Act. Okay, so we got one more. Homeowners Protection Act. Wasn't that still included in the HUD, in the Housing and Urban Developers, or the Fair Housing Act? Let's see. Examiners found that servicers were not in compliance with requirements of the Homeowners Protection Act, HPA, which requires the automatic termination of private mortgage insurance payments when the mortgage balance falls below 78% of its original value, or if the borrower is current on the termination date. CFPB issues supervisory highlights on a quarterly basis as it works to resolve violations using non-public supervisory actions. When these examinations reveal violations, the CFPB directs lenders and supervisors to implement immediate and appropriate corrective measures. These actions include refunds and compensation to consumers as the agency deems appropriate. To date, agency findings and resolutions have resulted in remediation of approximately 19.4 million back to consumers. So, ladies and gentlemen, plenty of things to consider. We have insights, we have the TRID, which I believe is supposed to be the Truth in Lending Act, or reference, HUD, compliance, good faith estimate, all this information on this individual's website. You can get in contact with them, get a consult. I don't know if he's going to do it for free, but, you see how I just read through articles and then just cross-reference through other websites. It's not a difficult process, ladies and gentlemen. Learn how to protect your rights as a consumer, as a national, as a person in any state doing business with whomever it is that you so choose, because you have the right to contract with whom you desire. So, more knowledge, more power. Peace.